defendants in court with all counsel except Ms. Abramson. The jury panels are not present at the moment. Counsel and the court have been discussing Ms. Abramson's absence and the reasons for it, as well as the schedule of the trial as to which witnesses will be upcoming, trying to get an estimate as to when both sides will rest. And that discussion at this point relates to basically the proposed testimony of witnesses for the defense. And those witnesses, as I understand it, will be testifying and complete their testimony next week. Is that the estimate of the defense?
Yes, Your Honor. Yes, Your Honor.
And then the people will have rebuttal evidence, and how long will that take?
4 or 5 days, Your Honor.
Are there matters that relate to objections or motions dealing with the testimony of the defense witnesses that are going to be testifying in this trial?
Yes.
And which witnesses?
Well, I think it would probably be most of them. And the question is whether the defense is going to be allowed to put the tape on that was given to the prosecution yesterday in their case and have discussions about the tape before the people actually present it in rebuttal. And so the people's position is that there should be, that unless and until the tape is in evidence, that there should be no discussion of it with the defense witnesses or by the defense witnesses. To put it on, to have the defense put it on would be hearsay. There is no appropriate hearsay objection that would allow them to put this tape on. And so it's the people's position that discussion among various defense witnesses of the tape would be inappropriate and would assume facts not in evidence.
All right. Other objections, assuming that objection was not well taken, what other objections will there be to testimony of witnesses?
Well, as to Ms. Smith, that would be the main concern, is anything she might testify to as to the December 11th tape. And then as to her testimony, I think we should just take it as it comes, and there certainly will be lots of irrelevancy objections, I suspect, and maybe striking of answers as non-responsive. But as far as issues, there are none that I can see right now. We've already litigated this with the court about her testifying at all. And then as to the other witnesses, the defense has indicated the people do object to Dr. Vickery testifying as being cumulative. And under, I believe, evidence code 722 or 723, the court is allowed to limit the number of expert witnesses. And so we have a general objection to his testimony, although we don't know precisely what it is he's going to say.
Has there been any offer approved by the defense in
No.
relationship to that?
No.
Is the defense in a position to do so?
Dr. Vickery, Your Honor, is a witness that Ms. Abramson is responsible for. I will indicate that the scope of his testimony probably will depend on the court's ruling as to the 1211 tape and whether we are allowed to play it ourselves. So that I right now, he is estimated as a one-day witness.
And what is the general response of the defense, realizing that Ms. Abramson isn't here and would be appropriate to have her present for the argument and resolution of it? What is the defense response to the people's position generally that the tape of December 11th cannot be played by the defense and that the testimony relating to it should not be received during the defense phase of the case?
Well, it's our position just in general, Your Honor, that an expert can certainly rely on the content of that tape in forming an opinion, first of all. And second of all, testimony, for instance, by Ms. Smith about the circumstances under which that tape were made is relevant to other issues in the case, specifically Dr. Oziel's pattern and practice in documenting his sessions with the brothers that are already in evidence, and there is an issue and a controversy as to whether those sessions are accurate. So her testimony about the circumstances surrounding the making of the October 31st, November 2nd notes, as well as the December 11th tape, would certainly be relevant to evidence that the jury has already heard. And the experts, I think, can rely on a tape which deals with the subject matter of the killings. If it seems to me the prosecution is taking an inconsistent position here. They've fought to get this tape on grounds that it's somehow relevant, and now they're saying that it's irrelevant to the case. It shouldn't be played by the defense. If they're going to bring it out in any event during rebuttal, I don't see the basis of an objection that our experts can't refer to it and rely on it in forming their opinions, since it's going to be in front of the jury in any event for its truth. It's not a situation where the court has to be concerned that the jury is going to consider it for its truth when the people intend to put it into evidence for its truth anyway during the rebuttal.
All right, what is the people's response to that?
Well, the people, just hypothetically speaking, if the people sought to admit the tape as to one defendant and not the other, then I think the defense would be in a different position. Wouldn't that be correct? And the people's position is also that under, I think it's People versus Price is the case that I cited in the amended motion to eliminate, and I believe there was another case I cited dealing with the fact that a defendant's statement, and there are definitely exculpatory parts of this statement, that a defendant's statement cannot be put in front of a jury under the guise of the expert having used it and relied on the hearsay and forming his opinion. So that would be the people's argument, is that the defense is not allowed to put on hearsay in that manner, and these newer Supreme Court cases support that position.
Well, also, Your Honor, in response to the hearsay objection, there is the obvious fact that the people have raised the issue of recent fabrication. So the exculpatory statements contained in the December 11th tape were admissible as prior consistent statements for their truth.
And we would argue that it does not, that particular section does not apply because the motive for fabrication had already arisen at the time that the tape was made in December.
You would not offer that tape as to both defendants?
Not at this time, Your Honor, but given the fact that we are going to be we will not be in session again until Monday, I think we'd be in a better position on Monday to address that issue.
Well, I didn't say we wouldn't be in session, I just wouldn't have a jury here.
Correct, but as far as
There are other matters that we'll discuss.
all right, but as far as presenting evidence,
So do I assume from that or infer from that you're in the process of making a decision as to whether the tape would be offered as to both or one defendant?
that is correct.
All right. Has the defense considered that as a possibility here in relationship to how the defense would proceed?
Yes, and it wouldn't seem to us to make a difference insofar as both brothers testified in front of both juries. Now, that may change depending upon the people's position. I'd like to hear what it is before I finalize our position, but it's conceivable that even if they did not offer it against one brother, that we would be in a position of offering it against both, but I really don't know until I hear who it's being offered against and in what context.
All right. Since it's just been disclosed to the prosecution, I think they should have an opportunity to review it and make a decision based on that review. The court won't make any final rulings on these objections that have been articulated here since Ms. Abramson is not present, and I think it's her client's wish that she be here for that. Is that right?
Yes, Your Honor.
Yes, sir.
Okay. The purpose of this session is just to give the court a preview of some of the matters that might have to be resolved.
Also, Your Honor, the people indicated no other objection to Ms. Smith. Do I take it then that the wiretap objection is no longer being asserted?
No, I mean, we still have to discuss it. I thought we were going to provide the court with the pages. I want to review the argument that we had before on that issue. And it may be based upon Mr. Burr's representations that we'll withdraw our objection, but I want to read it before I do that.
Okay, well, we'll take that up tomorrow, and as soon as you can give me the citations to the transcript of the earlier session on that, as well as the authorities that we had earlier discussed, we'll proceed with that tomorrow. There was also mention made that the prosecution wanted access to the testimony of Ms. Smith that was presented to Judge Albrecht in the in-camera proceedings in Santa Monica. And what is the defense position related to that?
Our position, Your Honor, is that the prosecution is not entitled to that testimony. This is an issue that the people did litigate in the Supreme Court when the Supreme Court ruled that certain sessions were unprivileged. The people filed a petition for a hearing with the court indicating that they would like the court to clarify that since the sessions were no longer privileged, that the people were entitled to access to the in-camera hearing, and the Supreme Court denied that petition for a hearing and left the opinion as written. And the opinion as written indicated what they were entitled to and what they were not entitled to. So it's our position that they're not now entitled to relitigate that issue, that that's something that was decided in the course of the prior litigation, and that ruling should stand.
And what you have just articulated, is that set forth in the opinion? Or is that just your information based upon some filings in the Supreme Court and the fact the Supreme Court denied a rehearing?
The fact that the Supreme Court denied the rehearing. There is a footnote in the court's opinion limiting what the court is deciding and what the court is not deciding. And one of the things the court says in that footnote, if my recollection serves me, is that they were not deciding on the people's right to obtain any information other than the 4 tapes that were being litigated. And that in response to that footnote, the people indicated in their petition for a hearing that since the court had overruled the claim of privilege, that must mean they were entitled to the in-camera testimony and asking the court to clarify. The court did clarify its opinion in certain other respects, but did not indicate by amending that footnote that they were entitled to the in-camera.
All right, what is the people's response to that?
Well, Your Honor, the Supreme Court upheld the privileges to 2 to 4 sessions. And it's my recollection that the point that people were making in the Supreme Court is that we should have been present during all the testimony, including that which was in camera, and the court said no, the proper procedure was the one followed by Judge Albrecht. As far as these particular transcripts, insofar as there is no privilege presently which would serve to protect Ms. Smith's testimony in front of Judge Albrecht, her testimony should be made available. There's no privilege that would cover that.
I think the privilege is 915 setting forth the procedure for the in-camera hearing. And there's no provision in 915 which indicates that if the court it rules at some point or some higher court rules the session unprivileged, that the people are then entitled to the transcript of the hearing. The testimony is being elicited under promises of confidentiality. And yes, later on it may turn out that the ruling of privilege is reversed, but the evidence is being submitted at that point with the assurance that it's going to remain confidential.
The only distinction that I can draw is that she was not a holder of the privilege, and she was not disclosing anything that was privileged to herself. And ultimately, it's because of the way the case has proceeded, it's turned out that she has not disclosed anything that's privileged to anybody. That is a distinction, that it's not the holder of the privilege who was testifying with some assurance that the disclosures would not be made to the opposition or to the public.
But the Supreme Court opinion does talk about her status as an eavesdropper and seems to draw a distinction between what she would be entitled to testify about and what Dr. Oziel is entitled to testify about. There is discussion of that issue.
All right, well, I'm familiar with that area and aware that the defense has taken the position in some discussions in the past during the course of the trial that she would not be permitted to testify about those things she said she heard, that her testimony has to be confined only to what it was that Oziel has testified about or disclosed to her. That's something we can litigate and resolve. I'm not convinced the defense position is correct in that regard, that if she overheard the same conversation that Oziel has testified about, it's mind-boggling that she would be precluded from testifying about what she heard, but would be required to only say that Oziel told her those things, even though she heard the same thing. To draw such a distinction would be rather extreme.
Your Honor,
I just asked the court to review the Supreme Court
Yeah.
language in the opinion on this because some of the higher court rulings on privilege are mind-boggling, and this may be one area. I've read that section, and it seems to say what we're suggesting. So I just asked the court to review that
Right.
portion.
Is it, as I articulated it, is that basically your position? That,
Yes.
that she could only testify about what Oziel told her occurred during the session, even though she overheard the same thing and could testify that she heard herself with her own ears exactly what it is that Oziel told her?
That's my position. Ms. Abramson, I think, may have a slightly different position. But that's our position.
and the people.
Wow, Menendez.
And the people's position is that it's clear from the Supreme Court opinion what they're talking about is that the fact that she was an eavesdropper does not vitiate the privilege, that is not something that would cause the privilege to evaporate because she heard it. And if the session is now not privileged, there's no reason in law that she can't testify to a non-privileged conversation. There's nothing in the law that says that a person who overhears a conversation can't testify about the conversation. So my understanding of the Supreme Court opinion is that her status as an eavesdropper did not give any relief to the prosecution in their argument that it was not confidential because she heard it.
All right, this to some extent relates more to Lyle Menendez and Eric Menendez in the context of these so-called threats, and what was overheard in that regard is basically what we're discussing. Is that correct?
Yeah.
If you'll support your position, I'll certainly review that.
The other thing I wanted to add is in other areas of the law, it's not, as so far as I know, I've never heard of a situation, for instance, where the defense brings an informant disclosure motion and wins after an in-camera hearing where the informant is produced as a witness. Typically, the result there is that the informant's name is handed over to the court finding that there's no privilege. But no one, to my knowledge, has ever said that the defense is also entitled to have the in-camera hearing at which the informant's testimony was revealed. I think the situation is the same here. That is, there's an assurance of confidentiality that is itself privilege. In other words, when the prosecution says there's no privilege here, there may be no psychotherapist patient privilege, but I think implicit in 915 is the idea that when it's being held out to the parties that there's going to be an in-camera hearing, that the assurance of confidentiality makes this this session or this testimony privilege by virtue of 915.
Well, certainly the particular hearing before Judge Albrecht was sanctioned by a penal code provision dealing with the seizure of privileged material, which called for a hearing pursuant to Penal Code Section 915, where evidence could be taken in the fashion it was. So it's a specific statute that calls for that procedure rather than just the type of hearing that we conducted in this court at the request of the defense, which is slightly different in relationship to Section 915, because it's not specifically spelled out in the penal code that there should be such a hearing. It's a discretionary hearing.
We would just draw the court's attention to the last sentence of evidence code section 915, which says that if the judge determines that the information is privileged, that's during the disclosure, neither he nor any other person may ever disclose without the consent of a person authorized to permit disclosure of what was disclosed in the course of the proceedings in chambers. The pivotal words are if the judge determines the information is privileged. So it seems that by arguing the disjunctive that when the information is not privileged, that disclosure would be mandated. And just because informant disclosure motions don't result in the revelation of what was disclosed in chambers doesn't mean it can't be done. It's just that it isn't done. But it could be that no one's ever tried to do it, or there's no case law on it.
Well, it's covered by a different code section as well.
Yes.
One thing that one might envision would be a situation where testimony is presented in the trial that is at variance with what was said in that in-camera hearing, substantial variance, and how that should be dealt with. Should it just not be the concern of the court or the parties that occurred? If a witness testifies at substantial variance to what the witness testified before a court in a 915 hearing,
That's a good question.
should we just sort of sit there and listen and say, well, that's nice, there's testimony under oath that's so you might want to consider that as well. As far as the people's rebuttal witnesses are concerned, are there objections to them by the defense?
Well, I think we don't know. I think that Mrs. Bazanich is calling down
Yes.
the list right now, so we're not exactly
Oh,
sure.
I thought you had finished that. Are you still doing it?
Yes, we're still shortening the list.
Okay.
I think we could, what we were thinking of doing, Your Honor, is meeting and conferring, and then maybe having the court take the bench again right before lunch, and we can tell the court what kind of progress we made and things like that, and we can discuss the rebuttal witnesses during this period of time.
Okay, and the time estimate you gave me for the people's rebuttal, did that include these revisions that you're going into? Or
Yes,
so you feel that this would be 4 or 5 days after you make your revisions?
hopefully, yes. We'd like to make it as brief as possible. I mean, that's what we're trying to do. But I think we came upon, last night, I think we counted up 16 witnesses, but some of those are really short witnesses. I mean, we could probably do 6 to 8 witnesses in one day if what I expect happens. Some of them would be very brief, and some of them are only as to one jury, too.
We do know one witness that we are objecting to, and that's Mr. Winhart, who is a blood splatter expert. And he was a witness who the people,
We're not calling him.
Perhaps it makes sense for us to discuss this with the prosecution.
Okay.
We have a 3-page list of witnesses and we don't know which 16 have been chosen.
Court requested that counsel complete their discussion relating to jury instructions. The people have been in the process of reviewing the instructions submitted by both defendants with an eye to providing the court with a list of those instructions that are agreed to and those that are not agreed to. And you indicate that you'll be able to do that today.
I think so. If not, I'll have it to the court first thing tomorrow morning. We're going to confer on that as well. That's one of the things we plan on doing.
and also relating to exhibits. You'll confer on that as well.
Yes. We're planning on doing that in the courtroom so we can have access to exhibits.
Okay, when did you want to do that?
Well, we were gonna, this morning.
Well, you expect to do all these things this morning and finish them all off?
No, but we're gonna certainly make a stab at it and see how far we can get.
Okay,
Wanted to talk to the court about scheduling for the next day and a half.
all right. As far as Ms. Abramson is concerned, your information is that she would not be available for the balance of today and tomorrow. Is that correct?
That's correct, Your Honor.
And she will be available for the balance of the trial without any further interruptions.
Yes, she will be.
Okay, anything else before we have the juries come in?
No, Your Honor.
Okay, let's have the jury panels come in, please. All right, we have both jury panels in court, and all defendants and all counsel except for Ms. Abramson are present. And let me give the juries, both juries, a little information. Ms. Abramson can't be here today because she has a family medical situation that she must deal with, and she can't be here today, and it will also make her unavailable tomorrow. But I have been assured that she will be able to be here for the balance of the trial, and that we'll proceed on Monday with both juries. But let me give you some more information. First of all, let me say this to all of you. You've been very conscientious, and you've been here whenever we've needed you. Great personal sacrifice to each of you, and it's a great imposition to each of you to be here on such circumstances, and we really do appreciate it. And I know that when you come here, I tell you to be here at a certain time, and you expect that things will proceed, and that testimony will be taken, and the trial will proceed without interruption. But because of circumstances occasionally that are beyond our control, things take a little longer, and interruptions do occur. And it's part of any trial. And with more people involved, more interruptions occur, and the trial seems to get a little longer because of that. And it's unfortunate that it does occur. But that does not in any way diminish the sacrifices you are making by being here and being so conscientious, being here on time and available whenever we need you, and paying such close attention to the trial as it's going forward. And we really do appreciate that. As far as the time estimate for the trial, I've been talking to the lawyers about that, and it appears that the time estimate I gave you, that the trial would be completed by the end of November, is not going to be accurate, that the case will go a little longer than that. My expectation is, from what I've talked to the lawyers about and their input, what they told me, is that the juries will probably start their deliberations towards the end of November or the 1st of December, in that time frame. As I've told you, we'll have different arguments for each jury, and also instructions separately for each jury. One jury would go first and then the other jury, so one jury would get a little head start as far as starting deliberations while the argument instruction is going on with the other jury. The decision as to which jury goes first has not yet been made. I'll do that after conferring further with the lawyers. There are various factors that go into that decision, and certainly if the scheduling of which jury starts deliberations first would in any way have any impact on your personal schedules, I'd like to know that as well. Or if, because of the revision of the time estimate for the length of the trial, if that would create any personal hardships for any of you, or anything that you want to let me know about, certainly I want you to do that. Let me know about any such situations. When we started the trial, I indicated that the length of the trial would go into the trial would go into the end of November. It could go a little longer, it could go a little less. I said it could go a little less, but obviously from what I've just told you, it's going to go a little longer than that. So if that time frame creates any problems for anybody, personal hardships, certainly let me know about it. We'll proceed with testimony on Monday at 9 o'clock. There might be some brief matters that we'll have to discuss with the lawyers, but my hope and expectation is that we will start Monday at 9 o'clock with further testimony. I have discussed with you on many occasions the jury's role in deciding this case based only on the evidence presented in the courtroom and my instructions on the law. And it's very important at this stage, since we've come this far, that you keep that in mind and that you follow that instruction, that you must evaluate the case and make a decision on this case based only on the evidence presented in the courtroom and my instructions, which I'll give you at the end of the trial. It's also very important that you as jurors not form any final opinions about this case. You have yet to hear all of the evidence. There's still more to come. And there will also be the arguments of the lawyers before I give you the instructions on the law. And until all of those things occur, it's premature to make any final decisions on the case, because you have to wait until all those things happen before you have a whole picture. And then you go into the jury room and discuss it with the other 11 jurors and make up your mind. So keep that in mind as well, as far as how you must approach your task as jurors. So at this point, unless somebody has a question regarding the scheduling that you'd like to discuss now, and if you do, if you would raise your hand, I'd be glad to discuss it with you. Yes.
Thanksgiving week, are we going to be in session on Wednesday all day?
Yes, unless there is a hardship situation that you want to let me know about. As of now, it's expected that we could probably be in argument during that time. And if we are, the effort would be to try to complete the argument and get into perhaps even the instructions that week so that one jury can be completed. But if there is a substantial personal hardship that somebody would experience by not being in session the late afternoon or something of that nature, I'd certainly consider that.
And will we be back in session on Friday or Monday?
Friday, the 26th, is a legal holiday, so we will not be in session on the 25th or 26th of November. Those are both legal holidays. All right. Anybody else have any questions?
And the excuse me, the continues into December.
Yes.
And how will that handle also the Christmas holiday?
Okay. Well, Christmas is observed on the 24th as far as a legal holiday, and New Year's the 31st. And as we get perhaps next week even, I'll give you a little more input on that as far as if there'll be any other days off that we might want to work out as a consensus here as far as dealing with that holiday season.
Thank you.
Right. Yeah.
Didn't you mention something about November 11th?
Yeah, that's a next Thursday. That's Veterans Day, and we're off that day. Yeah, that's a legal holiday. All right. Anybody else?
Would it be one jury's going to complete deliberations before the other starts, or
No.
just a couple of days for them to present closing arguments, and that would be the only delay?
Yeah, that's
So it's not going to be extensively longer than.
no. One jury will start deliberations a little bit before the other one, because the other one will be hearing argument while the first jury is starting its deliberations. All right. Okay, well, I'm sorry for the delay. I seem to be saying that quite often lately, but I'm going to say it again. And hopefully I don't have to say it much more during the course of the trial. And we'll see you back here all on Monday, November the 8th at 9 o'clock, at which time we'll resume. That Lyle Menendez is in court with his attorneys attorneys for Eric Menendez are in court. He is not, and the prosecution is present. We have all of.
One of my favorite supplements is Cunol turmeric. Turmeric helps with healthy joints and inflammation support, and Cunol has the #1 doctor recommended form of turmeric. Cunol, the brand I trust.
The jurors for both defendants in court. I'm sorry to keep you here this morning without having you come in to the courtroom, ladies and gentlemen, but I wanted to get as much information as I could before having you come in. And first of all, I want to welcome you all back. Good morning. The situation is that the defendant, Eric Menendez, is still unable to come to court. And it was something that I was only made aware of this morning. His condition is such where the doctors feel that he must be observed by them today. And from what I've heard in speaking with the doctors this morning, they feel that they must observe his situation tomorrow as well before they can authorize his transportation to the courthouse for further testimony or for further trial rather. And it's nothing to be concerned about, but it's a matter that obviously has to be monitored by the doctors. And because of that, it prevents us from going forward with a trial today. I've been conferring with the attorneys in regards to the schedule, and the defense has indicated to me, even with this delay here that we are encountering today and tomorrow, that they would anticipate, assuming we start up again on Wednesday, the 10th, that the defense portion of the case would be completed by Friday, Thursday being a holiday. So the schedule, as I've indicated, would be that after the defense rests, then there would be rebuttal evidence offered by the prosecution, and that would be presented by the prosecution starting next Monday, the 15th. And after that, there could be some short rebuttal evidence offered by the defense. And then when that is completed, which hopefully would be by the end of next week or the beginning of the following week, then we would go into argument one jury at a time and instructions, and then each jury would participate in its separate deliberations. So that's the situation today and tomorrow, that we will not be able to proceed because of the medical situation. And unfortunate as it is, we have to deal with these things as they arise and proceed with the understanding that the end is in sight, and we'll get there. Just hang in there and be patient, and we'll get there as quickly as we can.
So
Yes,
what
sir.
I hear you saying then, Your Honor, is that we may be in deliberation during or over Thanksgiving?
Well, you would not be here during the actual Thanksgiving holiday. That would be a time, obviously, when the court would not be in session. So you would not be here on the 25th and 26th. Those are legal holidays. But it's possible a jury could start deliberations before then you take a break for the holiday and come back and resume deliberations afterwards.
Yeah, I didn't know how that worked.
Yeah. No, you would be permitted to go home for the holidays, obviously. Anybody else with any questions? Okay, my apologies. And what we'll do is, if we learn anything tomorrow that gives us further insight into any problems that might occur regarding Wednesday, we'll call you and let you know of that if we find out about it. But at this point, you're all excused and ordered to come back here on Wednesday at 9 o'clock. And unless you hear otherwise, we'll proceed Wednesday at 9 o'clock. The jurors have left. Counsel and the court have conferred regarding the schedule here. And as I indicated to counsel, as soon as the court has more information from the hospital, we will impart that to you as far as the defendant's availability to come to court. As far as a schedule here in the trial, do counsel have any suggestions or requests relating to matters that must be resolved by the court prior to the completion of the case that we can do during today and tomorrow? We did discuss it briefly, and one suggestion was dealing with exhibits, another was dealing with jury instructions. And counsel also had suggested that you might want to confer briefly to see whether there are other things that can be addressed without the jury's presence.
Your Honor, it's my feeling that it's not just, without Eric Menendez's presence, I don't feel it's appropriate for us to do any significant discussion about jury instructions on anything of any consequence. I think our time would be better spent at least laying out the issues on the exhibits, for example. So of course the court can't rule on anything in his absence.
Well, certainly the court can confer with counsel regarding jury instructions and can do so on the record without the presence of the defendants. As far as any ultimate resolution of a dispute or hearing of argument on some matter that is of significance, then the court has the discretion to permit the defendant to be present for that, but there's no requirement that each and every event that transpires between the court and counsel requires the presence of the defendants.
The only other problem is that up until now, I'm completely ignorant of what jury instructions have been submitted to the court. Not anticipating that we were going to deal with this issue now, so I would like an opportunity at least to see what we've all submitted.
No, what I would suggest is that you review them and we proceed tomorrow morning with a discussion of the jury instructions. It would be a hearing. We'll have Mr. Lyle Menendez here just in case something of substance arises so that we don't have to wait and duplicate something later. But at least we'll get a start on those discussions so that it'll make things more smooth as the trial concludes and the instructions are finalized.
That's agreeable.
But I don't anticipate duplicating things over and over again in these discussions, but certainly preliminary discussions are significant in resolving any such disputes, getting input from each side as to why certain instructions have been submitted, the evidentiary basis of instructions, things of that sort. All right, so we can do that tomorrow morning. Any other matters that counsel wish to discuss today before we recess?
There is a discovery issue relating to Ms. Smith, Your Honor, which is that she provided a document to me, a copy of which I've given to the prosecution. And the document relates to an exhibit which was marked, I believe it's exhibit number 112, in which Dr. Oziel had written her a note for court, signed on his letterhead, containing a diagnosis. Apparently at the same time that letter was written, Dr. Oziel also wrote a second letter and containing a similar diagnosis and signed the letter in the name of Dennis Munjak, who was Dr. Oziel's partner at the time. The letter, at least on the face of it, is in Dr. Oziel's handwriting. And Ms. Smith informed me this weekend when she gave me a copy of that letter that the letter was referred or given by her to the Attorney General's office. And the Attorney General, in turn, referred the letter back to the LA District Attorney's Office for possible prosecution of Dr. Oziel. Ms. Smith provided me the name of the Deputy District Attorney in the Los Angeles District Attorney's Office who was in charge of that investigation, and the office apparently decided, based on some investigation, not to go forward with prosecution of Dr. Oziel. So that was the first we were aware of that, and I think that information is discoverable as Brady material and should be ordered, turned over to the defense at that time. That is the results of any investigation which was done into this issue. And specifically, we have information that there may have been a handwriting analysis done, which confirmed that in fact Oziel did write this letter.
So you are asking for any reports generated as a result of that investigation?
Yes.
Interviews of witnesses or expert opinions and things of that sort?
Yes.
Your Honor, I've asked Detective Zoller to go to the Beverly Hills DA's office where this deputy is now in charge and talk to her today and find out what this is about, so that he can get the information for the defense.
All right, the court would order that if there are any reports that were generated as a result of this investigation, that it be turned over to the defense.
Just the issue on the in-camera testimony, I'm not sure what Ms. Abrams' position is on this.
I don't think we should decide this without my client present. I think we need her to decide.
All right, there is a request by the prosecution to have access to the testimony of Ms. Smith that occurred conducted pursuant to section 1524 of the Penal Code and section 915 of the Evidence Code. And the issue was briefly discussed last week in the context of posited the situation of if Ms. Smith testified at variance to her testimony before Judge Albrecht, should not, at least at that point, this material be made available to the opponent of her testimony. And you did not respond to that last week, Mr. Burt, other than remarking that's an interesting idea or concept.
Still isn't interesting. I'm not sure I have an adequate answer for the court. I looked and could find no cases or other discussion on that issue, so it's really uncharted terrain at this point.
What is the position of the defense that Ms. Smith disclosed confidential information, material that was otherwise privileged during the course of her testimony? Is that your position?
Yes.
In the entirety of her testimony, or only a portion of it?
It would just be a portion.
It seems to me that there was a specific portion that dealt with potential attorney-client communication that might still be privileged, but the balance of her testimony really did not disclose anything that was privileged. Would you agree with that?
That would appear to be the case, and that's why I can't reconcile that fact with the fact that the Supreme Court said in its opinion that it saw no error in denying the people's motion to unseal the record. It would seem under the court's analysis that you're suggesting that since it was unprivileged, they should have access to it, and that's exactly what the position was that the people argued in the Supreme Court, and the court said there was no error in not unsealing the record. So
I think they want to.
The only thing I can come back to is the position I articulated to the court the other day, which is that there's an unfairness involved in promising confidentiality under 915, and then again, a court, either the trial court hearing the issue or someone down the line decides there was no confidentiality, and then the entire transcript gets opened up when the party submitting the evidence thought he or she was doing so under circumstances where it would not be revealed.
Well, the unfairness would be if something otherwise privileged was then disclosed, but there's no indication that Ms. Smith believed that she was testifying under some protective order that caused her to testify in a different fashion than she otherwise would have, or say anything differently than she would otherwise have said. And other than the limited portion that was privileged or could be argued to be privileged that she did disclose, the balance of it is material that she's already said to other people.
That's true.
And you have the anomalous situation of Detective Zoller, the investigating officer in the case, having testified in that hearing. And the defense position being that Detective Zoller can't disclose to himself what it is that he said. That's basically what your position is, what the Supreme Court position was in that regard. It doesn't make any sense.
It's not dissimilar to Dr. Oziel not being able to warn himself.
Well, that is a little bit off the point. So let's go back to our point here as to the merits of the defense position. If there is a specific thing that was disclosed by Ms. Smith in her testimony that was covered by a privilege that is still extant, then that is a separate issue. But if otherwise, it's material that is going to be subject to her testimony anyway, it's reason for it not to be made available to the opposition.
I think the argument we made to the court is the one we have to stand on, and realizing the logic of the court statement here. It appears that the issue was raised in the Supreme Court. It appears the court said there was no error in not revealing the content of the in-camera session. And the Supreme Court having spoken on that issue, it's our position that the court could not disagree with that under the law of the case. It's a law of the case that transcript should not be open. And I do appreciate and understand the court's problem with that argument.
Well, it's only a problem in that she is going to be a witness that will now be apparently subject to rehabilitation and or impeachment. And if her testimony is at variance to what she has testified before under oath, then it seems that the truth-finding process would mandate that that testimony be made available to trier of fact so that that can be used to evaluate her testimony.
Well, if it was a situation where the people had no other access, I think that would be true. But the fact of the matter is that the people do have access to a declaration, which they drafted and had Ms. Smith sign under penalty of perjury, which if the court compares the declaration to the content of the in-camera hearing, I think the court will see that it essentially leaves the people in the same position in terms of impeachment.
Except there might be some attack by the defense on the manner in which that affidavit was prepared.
That's true.
And as to the veracity of its content, which would be less successful if the attack was directed towards her testimony, which was given under oath, and she was questioned by defense counsel.
I can't disagree with the court on that.
All right, well, I'll review the case law that was cited by Mr. Bird in his brief, and the testimony is not that lengthy, so it wouldn't take long to resolve this matter. She won't be testifying tomorrow anyway, so we can discuss this further tomorrow. If people have any authority they wanted to cite on this subject, they certainly are free to do so.
If we have any way to there are a couple of cases I did want to cite to the court before we break today.
On what subject?
Well, this is something I might need to use with Ms. Smith, and it's just a case which says that memory loss of a witness is the equivalent of unavailability for the purpose of laying a foundation for prior recorded testimony, which ties in with what the court's been saying about her testimony in front of Judge Albrecht. And that case is People versus Alcala, 4 Cal 4th, that's at 742. It's a 1992 Supreme Court case. And then on jury instructions, I wanted to just cite a case that we're going to be relying upon and arguing about the self-defense instructions. And the court and counsel are familiar with it. It's Eris.
All right. Anything else here, or do counsel feel it would be fruitful to take a short break to confer about any other matters that we could put on our agenda for tomorrow?
Sure.
Or this afternoon?
If anything comes up, we will speak on the phone and we will notify the court.
All right, that's fine, but I want everyone back here tomorrow so that we can engage in discussions relating to jury instructions and exhibits.
What time are we?
9 o'clock. And as I told counsel before, while we're in trial here and we have the jury in court, we will be starting at 8:30 so that we can maximize the time prior to the jury coming into the courtroom at or near 9 o'clock, and also deal with matters after 4:30 that don't concern the jury, so that, again, we can maximize the jury's time in the courtroom without having them wait while we discuss these matters. So counsel should try to bring to the court's attention any matters that have to be resolved in relationship to legal issues that don't involve the jury, so that we can do that during that time frame, and we'll be here at 8:30 and be prepared to stay here after 4:30 so that we can resolve these matters.
With council's permission, I'm going to redo the list of jury instructions submitted by the prosecution in a vertical order as the court requested, and submit that today, and I can give the defense their copy tomorrow. It's just a format change.
He's back to us today.
Okay, I'll back to you.
All right, we'll be in recess then until tomorrow at 9 o'clock.